So we're going to look at children with psychosocial disabilities. And children are often forgotten in the human rights discourse. So I look forward to hearing our speakers here this morning talking about that. Our first speaker here this morning is Luke Clements. He's a Cerebral Professor of Law and Social Justice at the School of Law at Leeds University, specialising in public law and human rights on behalf of socially excluded groups. And he has advised on many cases before the Commission and Court of Human Rights, including the first Roma case to reach the court. So thank you, Luke.
Welcome back, everybody. Can you hear me over there? Okay. I'm going to be looking at a very specific issue. Is it okay? Okay. I'm going to be sort of telling a brief story about some research that we've undertaken. Before I do that, the title of the talk is The Rights of Children with Psychosocial Disability, Realising Article 19. And what I think, I spoke yesterday, what I would really like to do is focus on that word realising. That we've got to, in a way, move beyond looking at the text of the CRPD about glorying in that detail and try to look at sort of practical implementation issues, the sort of problems that confront you in the real world, how you realise these rights. And yesterday I was talking about a case, again, another sort of simple case, where on analysis you see that what we're doing is spending very large sums of money making lawyers rich. Even though we give very good process and practice rights, we don't want to, when we implement the CRPD, end up giving 10% of our budget to lawyers. And I'm going to look at a piece of work we did at Leeds where out of that sort of stuff comes some very fine detail that's incredibly important. I think that the case yesterday is incredibly important, that if you are going to give people really rights of substance, then you may have to forego some of the process rights, because the process rights can be incredibly expensive and give you nothing. That the man at the centre of that case got nothing out of £230,000 of legal costs spent on him in effect. You would trade that for substance. And out of this story, I think, comes a similar issue of importance. I've written a paper about, I haven't written a paper about this, I'm almost finished writing a paper about this, and it's called The Periodic Table Pinned to the Wall. Now, I was talking to Gerard earlier, and just trying to make sure that you all know what the periodic table is. The periodic table is one of the most wonderful scientific discoveries, and then we started theorizing whether the CRPD was the periodic table, because the periodic table is, for those of you who've read science, is really the key to understanding chemistry, the molecular model of chemistry. So I'll come back to that. But just to quickly talk about this research, I'm going to put this in context. So I'm looking at Article 19. We spent a lot of time on Article 19. Article 19 is the right to community living. And the key issue there, which came up in a number of really great presentations, is the issue of choice and control. The CRPD is sort of ambivalent about children to some degree because it rubs shoulders with the Children's Rights Convention. But the CRPD Article 23 stresses that children with disabilities have equal rights to respect for family life. So you're contextualizing the disabled person in a community, and the community is their family. and that they have a right to services to support them and their families, services for the child and the family. So we did some research at Leeds, a really small-scale pilot piece of research on young people with psychosocial disabilities. Most of these people have autistic spectrum conditions. As many of you know, autistic spectrum conditions, only about 50% of them have an associated learning disability, but many of them have behaviours that challenge. And so we were looking at that group, young people, children with autistic spectrum conditions. Nearly all of them have, they all had behaviours that challenged, and many of them had behaviours that challenged very severely. And the report is published. And we worked with a local disabled persons organisation in Leeds, a really brilliant one called the Access Committee. My chair is funded by a children's charity called Cerebra, which is an awesome charity. And what we use is we use students, we call them slaves, to do the number crunching on this work. And there they are, looking happy just before we started the research. At the end, they didn't look like that at all. And what it involved was going out with the disabled persons organisations, got great expertise in this work. They were interviewing 6 families that had had adaptations done. It's only a small sample, and they were based in Leeds. Now, adaptations to homes are incredibly important for community living. But nearly always they're associated with wheelchair users, making them accessible. And so we have good legislation in the UK about adaptations, but it has its limitations. But it's fixated with access, which is terribly important. But the legislation also says about making homes safe. And the group that don't have much success getting adaptations to their home are people with psychosocial disabilities, particularly autistic spectrum conditions, where they need space. They need space to burn off energy and other things. And they need safe gardens. Some of these young people were brilliant climbers, and they could escape and run away. And when we're trying to quantify the costs, this was a cost-benefit analysis, there were times when we had to work out how much a police helicopter cost for 2 hours, because that's how long it took to find the young person. They were brilliant. And it's £1,600 an hour, by the way. So it's very quantitative. I'm not a fan of quantitative work. I do a lot of it. But there are great problems about quantitative work. Anybody that's interested in the limitations of quantitative work, there's a wonderful book by Sally Engels Merry, recently out, called The Seductions of Quantification. It's a great book. So the students undertook the work. And I'm going to give you one brief case study called Bob. These aren't real names, obviously. These are... Bob lives with his mother and his sister. Students go and see this. I mean, students tend to be... Leeds is a brilliant university, a lot of overseas students. You need money to go to universities. They're largely from fairly privileged backgrounds. They're going into homes of people who, are disadvantaged, seriously financially disadvantaged. These are small, meagre council houses. And they are, even that experience is really important, I think. It's a radicalization program almost for students. And we were looking at somebody, a family, and the disabled person, we'll call him Bob. By now, he's 21. He's got behaviours that challenge. We're talking to his mother, Mary, and she's explaining, because Bob wasn't there, that he needs a lot of space. He needs space to let off steam, space to pace around. He's ever walking. Space where he can be on his own, space where he doesn't feel the urge to poke his sister. He's always very interested in poking people in the face, particularly his sister. He needs much more than that. It's immediate. So if he needs the bathroom and his sister's in the bathroom, he will kick the door down and drag her out, just because it's immediate. This is a very small house. Mary, her English is her second language. I'm going to say she's uneducated, not just because I think it's important for this story, but is one of the most impressive human beings you can come across in the sense of her commitment and her love for Bob and his sister. She has 3 different low-paid jobs just to keep them above the breadline. She's one of the sort of great heroes. And just seeing her and listening to her was a sort of Damascene moment for the students, and it was for me. They love Bob. He's, incredible. He's about 6'2" now, but it's incredibly difficult. And without more space, what happens to people like that is inevitably they end up in local authority institutions or NHS institutions. There is an inevitability to that for young people. And had they not had the adaptation done 8 years ago, he would have ended up in an institution within a year. There's really no doubt about that. Mary's health is not at all good. And that would have destroyed her emotionally, but it would have been an inevitability. It's incredibly difficult to get adaptations. There's a limit generally in the UK of £30,000, and this one needed £60,000. He needs 24-hour care, 7 days a week, 365 days a year, 1-to-1, and when he's outside it needs to be 2-to-1. Publicly funded costs for somebody like Bob in a social care home would be at least £100,000 a year and probably £250,000. But we costed it out at £100,000. So the arithmetic is pretty straightforward. So 8 years ago, he had adaptations. Within a year, if they hadn't been done, he would have been in local authority, a looked-after child. He's now got that extra bedroom. He's got an entry room, bathroom, secure garden. That cost £60,000. That's twice. That's very difficult to negotiate that, but this disabled people's organisation was very good at that. So for a one-off cost of £60,000, the local authority has, or the NHS has saved 7 years as a looked-after child. And that's £700,000. Now, we looked at 6 cases. Not all of them were successful, but on average, for £1 expended, the local authority, the NHS, saved £5, and they got that money back within 2 years. So on a sort of straightforward cost-benefit analysis, that's pretty impressive. The problem with the process, and this is the fine detail I think it's really important when we're talking about implementing the CRPD, is that the housing authority pays this £60,000. But the family is also looked after and funded by support from social care and the NHS, the healthcare system. In the UK, housing, social care, the NHS, education, they're all different authorities. They're all different budgets. Now, that's going to be true in nearly every country that you come across. They're going to have different budgets for different activities. So the housing authority gives the family £60,000 worth of adaptations. But the savings, and then that costs, so the housing budget goes down £60,000, but the savings of £700,000 in this case are enjoyed by either the local authority or the NHS. So the housing manager is under huge pressure to keep his budget under control. So he is doing everything he can not to spend money, even though for the UK PLC, This is, you should be trying to spend as much money as you can because it's making huge savings. That is a problem, the pressure on budgets that occurs in every area of public life, I think, in every country in the world. That you don't have this joined up system. So I'm sitting there with my students, 3 students there, discussing this with Mary. She's standing in a very meagre living room. And they're running through this questionnaire with her. And behind her, in a very small room, behind her, pinned to the wall, is the periodic table. And eventually, I'm completely unable to resist the urge to say, what is that doing there? Because it's completely out of context. And I'm fascinated by the moment. And Mary says, Mary didn't know what it was. She said, it's to do with my daughter. This is her daughter who had been poked and had been pushed and had, in fact, a very, very difficult time at school indeed, until 8 years ago when this work was done. And she said, I don't know what it's. She's doing science. She's doing A-levels now. She wants to be a doctor. She wants to be a doctor because she wants to care for people like Bob. She's concerned about that. Now, it's incredibly moving, really, because we're doing a quantification study. We worked out you save £70,000. But there's no box for the qualitative stuff. There's no box for a young carer or a sibling's life that's been completely transformed from somebody who would have probably been doing the sort of work her mother was doing, who probably will go to Leeds University and read medicine. There's no box for sort of the life-changing experiences for the students. They talked about that as one of the most important experiences in their lives. It's incredibly difficult to quantify the benefits of independent living, and that's a question the CRPD committee have asked of the UK. It's incredibly difficult to put a value on the community involvement of these disabled people's organisations that have enabled this family to live together. So that's all. Thanks very much.
Thank you, Luke. I'm sure you'll agree that was a fascinating piece of empirical research Luke spoke about, and the difficulties quantifying things. It's not always possible to quantify the benefits and things that happen in people's lives. So we look forward to reading the paper you're writing as well, Luke. I'd like to welcome now Dr. Katrina Maloney. Katrina is one of our own graduates here at the Centre of Disability Law and Policy at NUI Galway, and she teaches law currently at the University of Limerick. She did her LLM here in public law, and her PhD was entitled Empowering Children and Young People and Access to Justice Assessment of Mental Health Law and Policy. So I'd like to welcome Katrina here this morning.
Hey, good morning. Bring this down. Can everyone hear me? So it's great to have the opportunity to be here and to talk to you today about a topic that I've spent years sort of researching and analysing and trying to really look at the question for me is, are children viewed as rights holders, and how can we really make their rights real? So what I want to do today is, this is just an overview of the structure that I'm going to take. I'm going to talk to you in the context of Irish law reform, because we currently have a law reform process in the context of mental health law, and there have been reports with recommendations on how we should change the law, and in particular I'm obviously going to focus on children. So I want to take you through three stages And the stages are, first of all, these stages are based on a model developed by the UN Office of the High Commissioner for Human Rights. And it basically looks at how we can ensure there's effective implementation of rights in practice so that children can enjoy their rights in meaningful ways. The first stage is law, is the structure, it's called the structural. So it's a structural framework, ensuring that the rights are present in law. And the second stage that I'm going to talk about is called the process stage, and that's talking about how we ensure effective implementation of rights. And then the third stage is outcomes, that if you have this first stage, the structural, the legal framework, and then you have proper interpretation of rights, it will lead to an outcome which is the fulfilment of a right. So I want to fill up each of these stages with content, and because of course we've time limitations here, I'm going to focus on one main issue, and the issue is going to be capacity. And I've looked at the title I have here, Children Have Capacity, right? And what I mean by that is there are challenging issues around, do children have legal capacity? So I'm going to talk about that. But I want to focus on a case here in Ireland called XY minor. And I'm only going to look at this case in the context of explaining a little bit what Irish mental health law is for children. And because that case focuses on the issue of the right to consent and the right to legal capacity in the context of children, okay? And I'm going to look at the legal barriers and how I believe, because my whole aim here is to really look at the positives of the CRPD and how through a law reform process like the one we're currently looking at here in Ireland, we can use the CRPD and its principles to create real change in children's lives when they're in a hospital setting. So I'm going to look at, first of all, I wanted to outline the differences before I look at the case XY minor and take you just through it, just to highlight some of the issues around mental health law and children. But children as rights holders, and I put a question mark here because there is this huge issue in relation to our children rights holders, and the conflict goes right back to the theoretical underpinnings of what is the nature of a right. And I don't want to get into the theory about it, but I just want to say that you have a lot of people that say, yes, children, of course, they have rights, but the rights they have are welfare rights and protection rights. Okay? What the Convention is saying, and indeed the CRC, which is the Children's Rights Convention as well, is saying that children are rights holders and they shouldn't have just these welfare protectionist rights, but they should also have self-assertive rights, which include the right to self-determination. So differences, I want to just highlight the differences in the Mental Health Act in Ireland, is what I'll be talking about, and then the Convention. So in Ireland, our Act, we have different provisions that apply obviously to children and to adults. Some of them I just wanted to highlight here is in relation to treatment and in relation to the right to consent. Adults have a right to consent under mental health law in Ireland if they have capacity, and there's a capacity assessment there. There's no right in Irish law for children to consent. So that's the issue that I want to talk about, this lack of a right in the first place, a lack of the structure, the first stage. So there's a presumption of capacity for adults, but in Irish mental health law, there's a presumption of incapacity for children, right up, and to define children in the law, they say it's from 0 to 18 years. So when I'm looking at differences here, and I'll highlight this again later, but the Convention talks about people being treated equal before the law. And if we look at Irish mental health law and our general healthcare law, you'll see that children with mental health problems that are in inpatient CAMS that I'll be referring to, which is Child and Adolescent Mental Health Services, aren't treated on an equal basis to their counterparts, because we have a law here that says children from 16 years of age up can consent to medical treatment, but in the context of can consent to general treatment, but in the context of mental treatment, you must be 18. So you have this discrepancy between ages based only on the mental health impairment of the child. So that's an issue. And adults make decisions in their best interests. And this applies to adults as well under the Act, but I'm highlighting this just to talk about the difference in the application of the best interests according to outdated perceptions of what best interest is, and that's the welfare the protection model that applies to children. And I think that the magic in the convention is how we're going to change and reconceptualise what best interest means in its application to children. And I think that that's one of the huge significant factors that the convention adds to children. So looking at the convention, the differences, and I've sort of referred to them, but it's basically around, if we look at the concept of legal capacity in Article 12, and I'll be referring to that again to expand on it a little bit, but we've talked about it already over these few days. Basically, you have Article 12 saying you can't have substitute decision making, it has to be supported decision making, best interest can't be applied to adults. And capacity assessments, there should be no capacity assessments. It should be everybody's presumed to have capacity, and after the fact, if there is an issue, then it's you provide support rather than you apply a capacity test. The difference here is you have the CRPD, which for children allows the application of best interest principle, it allows capacity and it allows substitute decision making. But I think what it does do is creates the paradigm shift that everyone's talking about in the application of how those principles should be interpreted based on the values and principles of the convention. Okay, so I put this here just to say, I asked the question, are children rights holders? Yes, they are rights holders, and they have many rights, and these are some of them. But my issue is with the second stage that I'll be talking about, which is we have to improve the interpretation and the understanding of the concepts that apply to children. So this is the case, it's XY a minor. I'm just going to tell you a bit about the facts and then focus on the issue of consent and capacity. So you had a 15-year-old girl when the case was first taken in 2012, a 15-year-old girl who was admitted under our mental health legislation under Section 25, which basically says that you can be admitted if you have a mental disorder as defined under the legislation, and also that treatment is necessary. So you'd be admitted, and that's why she was admitted. And she was treated under Section 61, which has no recognition of her right to consent or her right to evolving capacity, respect for evolving capacity. So she was diagnosed with bipolar disorder, and she was admitted because of a suicide attempt. Okay, so she was treated against her will, forcibly, and she was physically restrained when she was treated. The case was taken by the HSE, which in Ireland here is the Health Service Executive, okay, the body responsible for the care and treatment of children when they're in these inpatient units. And what they wanted to do was take a blood sample from XY to monitor the side effects of the treatment. She didn't want this, so this was against her will, and she was they took a case basically to ask the court, could they forcibly take the blood sample from her? And the order was that yes, and the parents consented, and the court said, yes, you can forcibly treat this child under the legal authority of the court. Go forward a year, and XY, a minor herself, took a case against the HSE and against Irish mental health law, saying that it was absolutely incompatible with her constitutional rights to bodily integrity and her ECHR rights. So the issue that I want to focus on, there's many issues that come up in this case, but I want to look at is that there was no right for her to consent. She argued that there was no procedural protections of her right to consent. Okay, and they weren't. And if you look at the European Convention for Human Rights, for example, it says that there must be safeguards there, such as supervision and review of treatment, and indeed the right to put the person in a position to give an informed consent in the first place. So she was held to lack capacity to refuse consent. The issue I have here with this is that it's not she was considered or held to have lacked capacity because she first had a right to a capacity assessment and she had a right to give an informed consent. It was because it was a default position. Her parents gave consent or the court gave consent, and she doesn't have any rights in this context. It was also held that her best interests were served by permitting the taking of the blood sample. And my issue with this, and I'll talk about this when I move in, because this is just focused on the law, and I want to, when I move into the second stage of the interpretation of it, I'm going to look at how I have issues with this interpretation of the best interest principle in a paternalistic manner, and how it leads to complete denial of children's rights in these types of contexts, and how again I think the convention can improve these types of situations. Okay, and I just want to highlight here that this is still the first stage and the law, and there is the jurisprudence of the United Nations committees, so the monitoring bodies such as the CRC and the CRPD committee, they're coming out with strong comments, and this is based on concluding observations for Ireland, saying that you have no legislation in your mental health legislation that does not recognise children's rights, and it does not recognise their capacity. So this is a huge issue, and under our current law reform process, I think that the CRPD can add huge benefits to it. And this is from the CRPD basically saying that you have to abolish forced treatment. It's not even acceptable. So if this is the narrative, then something needs to change. And I think that the interpretation and the application of children's rights in accordance with the Convention can make huge changes for children. So, just to focus on the issue of consent and capacity, what is consent and what is capacity when you're looking at children? So consent involves 3 elements. A legally valid consent, it must be given by a person with capacity, it has to be an informed consent, and it has to be given voluntarily. The huge challenging issue for children, as I've been saying, is in the context of mental health law, they're seen to not have any capacity. So they're seen to lack capacity. And first of all, this is discriminatory when you look at children being treated on an equal basis with others, so other children in the healthcare setting. So I'm looking at children from 16 years up, but also just to recognise that we have this mature minor principle, not in Ireland unfortunately, and we'll see in XY a minor that said that the Gillick competence test doesn't apply in Ireland in the context of children under the Mental Health Act. But it's known as a mature minor principle. And what it says is that even children under 16 years, if they have the capacity based on age and understanding, so you're talking about capacity assessments that are allowed in the context of children, that even children under 16 should be entitled to respect for their evolving capacities and to give a consent. And we don't have that here in Ireland, and I think that's unfortunate. So assessments of capacity are going to apply to children. I know the Convention says that they shouldn't apply to adults, and that even the functional approach, if you look at the different types of assessments, the status-based and the outcome, and this functional approach that I'm sure they've been talking about, they believe it's not appropriate to apply that to adults, but it doesn't apply here to children, and I think that if we could have something like that in our mental health legislation to allow for capacity assessments, it would be an improvement on what we have at the moment. So those are the barriers in national law for children. I want to move on now on how I think that international human rights, such as is available in the CRC and the CRPD, how they can provide legal empowerment of children. So again, this is still the structure and element, and when I move on to the interpretation part, I think that's where the importance of these rights happen. But we talked about textual rights, and you have all of these beautiful rights that I'll be talking about. Best interest, children have a right to the best interest, evolving capacity, and the right to be heard and participate. And there's many other rights that they have that I've highlighted here. You can have a look at, but I know I don't have the time to spend on it. But like Article 25, the right to a periodic review of treatment, and children don't have that in Irish law. And then we have the CRPD provisions, which really reinforce and strengthen the rights that are available in the CRC. And I think when I'm talking about their interpretation and how the monitoring bodies say they should be interpreted, you can see where the change can happen in moving from outdated concepts to these newer concepts that underpin the Convention. So we have in the CRPD Article 3, its general principles, legal capacity, and Article 7 is based on children with disabilities, and I'll be expanding on these as I move into the interpretation section, but this is still the stage about law, and this is the last one in relation to law. We also have in the Convention, non-interference with physical and mental integrity, and free and informed consent, the right to free and informed consent, and how I believe that these rights need to be put in Irish law for children. So this is the stage where you look at interpreting rights to make them effective. So if you look back to what I think are, if you look at the textual rights in the conventions, in all of these slides as I've been talking about, and they're very beautiful expressions in the law of what rights are. And I think they really get lost in translation if we can't interpret them and apply them in practice in the hospital settings to children. And I believe developing mechanisms around participation in treatment decision making is what the Convention can add, and how we can, legally empower children to realise their rights, which is what the rights are there for, is so that they can be enjoyed. If they're not enjoyed, they're certainly lost in translation. So the right to respect for evolving capacity, I'm not going to focus too much on it because I've been talking about it, but core in it is that it recognises that children indeed have capacities to exercise their rights. Although they might be developing, they can still exercise the rights. If you look at Article 3 in the Convention, what does it add? This is where the magic happens. It says we must be supporting children to exercise their rights, not denying them their rights, but supporting them. And that's the crucial, I think, takeaway that we can from the CRPD is if you look at Article 3 and 7 and Article 12 and apply them to children, it's about building all of these opportunity structures for them to participate in decision-making processes that we don't have in our Irish mental health law. And I'm sure there are other laws in other countries around the world that also don't have these sort of participatory capacity building frameworks. And so I talked about our children rights holders, and I think that if you look at the difference here, or if you contextualise it within Article 12, Article 12 talks about having, the capacity for rights and the capacity to act, and it's supposed to apply, unrestricted to adults, but obviously there is this acknowledgement that children need to develop their capacities. But importantly, I think, and if you look at what the CRPD committee has said, Article 12 absolutely applies to children, but just with the caveat that it needs adjustments around developing capacities, not denying capacities. Okay? And just to look at Article 12 in the CRC, which is a different convention, if you're talking about a capacity assessment, how it must apply to children, I think the model in Article 12 is the model that must be applied in all situations in relation to decision making for children and how their capacities should be assessed. So just to look at the interpretation, the barriers, I'm looking at the barriers in the second level, so effective implementation of rights. The barriers are, if we aren't going to interpret rights in line with the values and principles of the Convention, or these new understandings of best interests, and we continue to interpret and apply justifications in the law, which is what X, Y, a minor and the court did, then we're just going to lose out. These rights are going to continue to be lost in translation. So if we look at the justifications given in this case, the need for treatment because of risk to self, and the best interest and the paternalistic intent of the legislation. So I think the overuse of this justification of the need for treatment is a huge issue. And when I come to the perspectives of the psychiatrists in some studies that were done on how they justified their decisions for coercive care for children and child and adolescent mental health inpatient services, I think that allowing these justifications, the need for treatment without really questioning, are the psychiatrists documenting their value arguments, their ethical obligations or their ethical considerations around their justifications, rather than just solely basing it on the law, or the law says, we can treat if it's necessary. And as I said, the best interest principle being very paternalistic as it is. And I think that the Convention, if you move into the process of the outcome and the enjoyment of the right, I think the magic here is the Convention gives us the opportunity to change the interpretation of the gatekeeper concept for children, which is best interest, because that's where all their rights sort of stem from. There'll always be this best interest assessment. And if we look at it from the context of paternalism and welfare and protection, then we're losing out in the fact that children actually have these self-assertive rights as well. So I've put up some of and I'm aware of time. So I've just looked at, and I've already talked about it in relation to barriers around justifications and interpretation, but there are very, very little research done on the attitudes of professionals in the context of children, and also on children's experiences themselves. But if you do look at some of the studies, it shows, like the study in Ireland basically, when professionals were asked about issues around children, these were what came up, Oh, we've major problems, legal position of adolescents. We don't understand how we're supposed to apply to them. And then if you look at other jurisdictions, I looked at Finland and Sweden, and they said that basically they believe that they're completely justified by using these outdated perceptions of best interests and treatment to coercively treat children. And I'm just going to finish by looking at I think if we look at what children are saying themselves, what the monitoring bodies are saying, and these are the quotes from what children have said themselves in relation to treatment, and what the monitoring bodies such as the CRPD committee is saying, and like I have said, around interpreting rights in the right way to make them meaningful, then we can change coercion in some ways for children, first of all, by saying that they actually are entitled to a right to consent, which puts them in a position to give informed consent and to have their capacities assessed. And I believe that that's what they're asking for from the studies that I have seen. And just to finish then, so bringing that forward to the convention, everything that's there and the magic in it. And if you look at the law reform process in Ireland, I do believe it's having an impact. I just want to highlight the reform process that we have here in Ireland. The report has said that, yes, we're going to take into consideration will and preference, the right to capacity for children and their right to self-determination, which I think is because the CRPD and the movement behind the CRPD. So thank you.
Thank you, Katrina. That was a real fascinating insight into children and how the CRPD can help realise children's rights and actually make them meaningful as well, particularly in relation to legal capacity. I'd like to welcome now Shivaun Quinlivan, one of the lecturers here in our own School of Law at NUI Galway. Shivaun's research interests include the rights of people with disabilities, with a particular focus on education and employment. Shivaun was the first director here of the LLM, sorry, could we have silence please? The LLM in International and Comparative Disability Law here in the centre, so she was the first director of that. Her talk today, the title of her talk today is The Right to Inclusive Education for Children with Psychosocial Disabilities. Thank you, Shivaun.
Well, I'm going to try my best to stick to the time. So on that basis, I may skip past a couple of slides because I realise I am definitely over. So firstly, I'd like to start my paper by thanking both Charles O'Mahony and Gabor Gambas for inviting me here today. It's a really great privilege to be with you on this occasion. I am addressing the concept or the right to inclusive education for children with psychosocial disabilities. And particularly I'm kind of trying to focus in on what is inclusive education and what does the concept actually mean in international human rights law. So I've structured the paper as follows. I've just a very brief introduction to the right to education, an even briefer setting out the theoretical underpinnings of the right to inclusive education. And then really the focus of the paper is going to be on what is inclusive education, what does it involve, and how do we achieve inclusive education. Education has been described, and the right to education has been described as an empowerment right or a multiplier right, in that access to the right to education can open up your access to every other right in many ways. One of the former UN Special Rapporteurs on Education, Katerina Tomaveski, said, "It is the bridge to all human rights." And the Committee on the Rights of the Child describe it as the state in relation to children with disabilities that the lack of appropriate education and vocational training opportunities discriminates against children with disabilities by denying them job opportunities in the future. So the right to education is more than about access to a school. It's more than about access to a curriculum. It is about access to your future and your potential. And so that's the reason why the right to education is probably one of the more fundamental, in my opinion, and I will express that as my opinion, one of the more fundamental rights in any human rights convention. It has the power to unlock the potential of any individual and therefore open up their future opportunities. I'm going to skip on to this very quickly. It's clear that the legal and policy approach to how we approach the educational rights of children with disabilities has undergone what has been described as the very overused phrase, the paradigm shift. And this is no different. So I'm very briefly going to use this picture to explain what I mean by the paradigm shift. And it's the notion of moving from the medical model of disability, where the focus is on what's wrong with that individual and how we fix that individual. And in this context, the problem here is clearly that the person can't walk, so therefore they can't access the polling booth. Applying the social model to the same scenario is we focus on the barriers to exclusion and we try to address those barriers. So the problem here is clearly the steps, and the steps exclude that individual from accessing the polling station. And just because I'm conscious that this PowerPoint also may be exclusionary, just to clarify what this image is, it's an image of a wheelchair user at the bottom of a flight of stairs trying to get into a polling station at the top of a flight of stairs for anybody who is visually impaired within the audience. So it's the move. What we're trying to do is see how do we move the education system in that context. In the education context, the medical model, it means that the child is required to fit the education system that actually exists. And if that child isn't able to adapt to that system, a system not created with them in mind, then the failing is with the child. So what we do is we remove the child. We put them in special education or segregated education or special classes. And we remove the child from the main education system. The social model, and you apply this in the education context, looks to what supports are needed to ensure that the child is included within the system, and what are the systems, what are the barriers to that child's participation, and how do we address those barriers to allow the child to participate within that education system. It is the social model and the human rights approach to disability that underpins the entire UNCRPD. And it has to be said that at the outset, changing the physical infrastructure of a school is straightforward. It's very straightforward. I'm not undermining or notwithstanding the resource implications, it's not a difficult issue. Changing the curriculum, changing the system, changing the attitudes within an education system is much more difficult. And that is the challenge that we're faced with. And that's the challenge that we're going to address, I suppose, hopefully throughout this paper. And I was speaking yesterday to a mother who's in the audience, a woman in the audience, who was telling me the story about her son who was in school. He's 4 years of age, or 5 now maybe. Started junior school last year. He's visually impaired. They notified the school in advance that their son was coming to the school and what his impairment was. He arrived at school, and one of the issues is he had difficulty with depth perception. So in that context, the school had painted the steps yellow to show that the different depths and all the steps. The school worked out what seats he could sit at to see the board. They worked out how they addressed it. So it was this process of working out, well, what works? What are the barriers? How do we include him? But the most important element of that lesson is the attitude of the school. The school were willing to try, and by virtue of them being willing to try, they made his educational experience a positive experience. And it's trying to change that attitude can be one of the biggest barriers in relation to inclusive education. I'm going to skip past this. One of the issues here is that I'm also kind of suggesting, just very briefly, that the introduction of the right to inclusive education that is enshrined within the UNCRPD is building on previous conventions. This isn't a bolt out of the blue. This didn't come from nowhere. We can see from previous conventions that there was movement towards the notion of inclusive education. We can see it in the general comments under the International Convention on Economic, Social and Cultural Rights, as well as under the general comments in relation to the rights of the child. But for our purposes today, we're really focusing on what is inclusive education. And Article 24 of the CRPD says that state parties recognise the rights of persons with disabilities to education, with the view to realising the right without discrimination and on the basis of equal opportunity. State parties shall ensure an inclusive education system at all levels. The difficulty is the phrase is entirely undefined, and there is in effect no clear image or vision of what inclusive education should look like. There's no jurisdiction in the world that has the system that we should all be modelling ourselves on. So as a result, policymakers are trying to find out and find their steps on how to achieve an inclusive education system. And inclusive education is understood more often in the breach than in the observance. We know, well, that's not inclusive, but we can't always identify what is inclusive education. So I'm going to look at some of those breaches with a view to building up the picture of what an inclusive education system should look like. And there are 4 approaches to the education of children with disabilities. One is that we exclude children with disabilities. Another is that we segregate them. A third is that we integrate them. And the one we should be aiming for is the inclusion of children with disabilities. And exclusion, as the name suggests, is that we exclude children from the education system entirely because of their disability. And in legal terms, it's undoubtedly problematical, but it's also prevalent. Exclusion, for another former UN Special Rapporteur, this time Mr. Werner Munoz-Villabus, and I apologise for all pronunciations of names, but in 2007 he said that the number of children with disabilities attending schools in developing countries range from less than 1 to 5% of those children. In 2010, a report, the Global Campaign for Education, estimated that 69 million children were in school. Girls were more likely to be excluded, as were children with disabilities. So exclusion is a prevalent concept, but equally it happens in other ways. In a case in Ireland, the case of A. MacD, the names are anonymised, versus the Minister for Education, the child at the centre of the case had been diagnosed with a number of impairments that included a moderate intellectual disability, significant challenging behaviour, a history of attachment disorder, attention deficit hyperactivity disorder, and a couple of other possible syndromes. The evidence from her father was that, and it was a father was raising her on his own with her brother, was that she was prone to violent outbursts. And as a result of a violent episode, she was expelled and excluded from school. At the time of the hearing, she'd been out of all schooling, which is a constitutional right in this jurisdiction, for over a year. And the court accepted, and she was at the time of the court hearing getting 2 hours home tuition a day. The court accepted that she was entitled to a school place. She doesn't have one, and that it was having a harmful effect on her development. The court also accepted that she was going to suffer ongoing damage if there was an inability for her to attend school. The judge went so far as to say that if she was not found a school place, her future life will be difficult in the extreme. But the court did not actually then take the next step of mandating that she be given a school place. So they accepted that there were failings, but did absolutely nothing to actually counteract those failings and handed it back to the legislature to address. And that situation was decided in 2013. So while clearly unacceptable from an international human rights perspective, the denial of the right to education for children with disabilities is still prevalent. A second approach is segregation, and this is defined by the UN CRPD Committee as occurring when education of students with disabilities is provided in separate environments designed or used to respond to a particular or various impairments in isolation from children without disabilities. And again, a system that is prevalent is actually preferred by some jurisdictions, as we will see. And these schools are often kind of developed along impairment lines: a school for children with autism, a school for the blind, a school for the deaf. And in the context of segregation, it is absolutely widespread, as is evident from a number of reports. One 2006 report highlighted in particular the situation in Belgium, where over 10% of the population, the education population, are in segregated education. And this is the subject of a case that is currently before the Committee on the Revised European Social Charter, challenging that percentage of segregation. But what's interesting in the facts of that case is that the Belgian government spent a 5-to-1 ratio on those children that are in segregated education. So if you're in segregated education, 5 times more is spent on your education than if that same child is in an inclusive setting, which means the state are actively supporting segregation, but financially. And if that money went with the child, arguably the inclusive education would work much better. In China, there is, in response to the provision of the duty to provide inclusive education, the Chinese government have been building and continue to build segregated provision. And in this regard, the Committee for the CRPD, in their concluding observations, have said that the concept of inclusion is one of the key notions in the Convention and should be especially adhered to in the context of education. If we include children, all children within our education system, all children benefit from that. Not just the children with disabilities, but every single child in that classroom, because that is the society we want, hopefully, to develop. And I think it's incredibly important to be critical of segregated education, not necessarily because of the actual educational interventions that happen in that context, but because of the impact of segregation. And in the case of Orsis and others versus Croatia, a case that went to the European Court of Human Rights, which related to Roma children, the psychological study was presented to the European Court of Human Rights on the impact of segregation. And they said that it produced emotional and psychological harm to the Roma children. This harm was expressed in terms of low self-esteem and self-respect and problems in the development of their identity. It's undoubted we can draw analogies from that in the context of children with disabilities. And I'd like to give two brief examples, if I may, of that. One relates to a former student of mine who was visually impaired. And because of his visual impairment, he was sent to segregated or special education. And when we were discussing the concept of segregated or special education, he said that he'd got a great education, but he described it as social death. He was no longer part of the society, and he felt that. A couple of years ago, I was at a conference that was organised by Luke, and at that conference, Jane Campbell spoke. And there was one story she told. She was a very famous and celebrated disability activist, and now she's the Baroness Campbell of Surbiton. But she recounted a story of her childhood when she was sent to special education, and she begged her mother for the school uniform of the local school, so that, and even though she went to the special school, so that when she walked to and from her special school, nobody would know that she was going to the special school and that she looked like one of the children who was going to the local school. And that speaks to the anecdotal evidence of the impact of segregation on children. There is also the Brown versus Board of Education, where we accepted in the context of race that segregation was wrong as far back as 1954, yet in 2017 we're still addressing it in the context of disability. A third approach is the approach that is taken in many countries, is this notion of integrated education. And it is the process of placing persons with disabilities into the existing system as long as they can adjust to that system, and there may be supports provided in that context. So children within this system are included if they can meet the requirements of the system. Now, there will be supports and there may be additional benefits, but for it to work, those supports must come into play, and there's the problem. They don't in an awful lot of situations. In many jurisdictions, integrated education is under-resourced, and many of the children with disabilities are effectively abandoned within the mainstream because they can't access the education within there. Moreover, and in a particularly, I suppose, unpalatable situation, the child with a disability is mainstreamed or integrated is only guaranteed a continued place in that system if they don't impact on the educational attainment of the other children within that system. So it's often the case that if the child with a disability is behaviour or disability is seen as somehow impacting on the educational attainment of the children without disabilities, then that child's place may be altered as a result of that. In effect, putting the educational rights of children without disabilities above the educational rights of children with disabilities. Fundamentally, it is also the medical model of disability, and it is the integrated system, is that we have this system that we force everybody to fit. And again, this is an image, just so it's an image of which states, it has a teacher stating, for a fair selection, everybody has to take the same exam. In this case, it's please climb that tree. And it's a picture of different animals. It's a bird, it's a monkey, a penguin, an elephant, a fish, and a dog. We do this to children every day. We say, for a fair assessment, here's the exam. And we don't take on board the different abilities and talents of those children. So the CRPD committee have again criticised integration, stating that placing students with disabilities within mainstream classes without accompanying structural changes to, for example, the curriculum, teaching and learning strategies does not constitute inclusion. Furthermore, integration does not automatically guarantee a transition from segregation to inclusion. So the first thing to note is that it isn't a stepping stone process. We don't go from exclusion to segregation to integration to inclusion. You can go straight from exclusion to inclusion. The point is inclusion is the goal here. This isn't a process, this isn't a stage, but integration in itself is not inclusion, contrary to what it is. So the question is, what is inclusion? Well, this is where it becomes more difficult. And again, I have a visual image. So we can see the different, it's 4 circles, and the circle of exclusion has a circle. Within that circle, the children are learning, and those that are children with disabilities are excluded from the system. Segregation, as we've looked at, has that circle of inclusion, and a second smaller circle where children with disabilities are taught somewhere differently. Integration moves that smaller circle into the bigger circle, but again, they're not included with the other children. Inclusion, which is the goal, is that, and arguably then there shouldn't be green dots. That's my other theory on this one. Inclusion means that we're all in the education system together. It is described as, by the CRPD committee, as a process of systematic or systemic reform, embodying changes and modifications in content, in teaching methods, in approaches, structures and strategies in education to overcome barriers, with the vision serving to provide all students of the relevant age range with an equitable and participatory learning experience and environment that best corresponds to their requirements, preferences. In an inclusive system, children from the local community are learning together. This is dramatically different to the system that many of us learned and experienced. So it requires the education system to be responsive to the children in front of them, whatever the needs of those children are. In effect, what has been required is the education system is sensitive to the needs of children. And that is sensitive to the needs of children with psychosocial disabilities, sensitive to the needs of children from Indigenous populations, of refugee children, of children who've come to school hungry, of children. It is responding to the people in front of them, as opposed to asking children to fit a system. Inclusion is a process. That's to say that it's a never-ending search to find a better way of responding to diversity. And if you go back to that example of the child, the 5-year-old child who is in primary school who is visually impaired, one of the things that his mother said to me was that, they said that as things change, we'll just keep reassessing. And that's the point, is that it is this process. What is right in junior infants or for kindergarten, probably is what many of you know, won't necessarily be right for an 8-year-old child, won't necessarily be right for a 12-year-old child, but it's a process of finding what works. So inclusion is about, and this is how they've described it, it's about 4 issues. It's about the presence of the child in the class, and that's not sufficient on its own. It isn't enough to allow a child access to an education system where they sit and gain no meaningful knowledge or are not able to participate. So it's presence, which is, yes, important. Second element is participation, the ability to participate within your own education, the ability to benefit from that education. So it relates to the quality of their experiences while they're there, and therefore they must incorporate the views of the learners themselves. What works for the children? How does this work? And achievement is also about the outcomes of learning across the curriculum. This doesn't amount to test results, and this isn't about how many A's and B's and C's you got, is that the child actually developed within that education system over the course of the year. And it involves a particular emphasis on those groups of children and those learners who are at risk of marginalisation. And that isn't specific to children with disabilities. There's lots of children at risk of marginalisation. But if you have a system that is sensitive to the children in front of them, then it will be sensitive to children with disabilities. It will be sensitive, as I said, to people from Indigenous populations, the child who's hungry, the child whose parents had a fight that morning and are separated and is distressed. It will respond to the needs of the child. So in order to achieve an inclusive system, we need the current system to change. And that's incredibly difficult to achieve. Because one of the issues about systems is systems protect themselves. They naturally protect themselves. So it's therefore important that we work together as lawyers, as disability rights activists, as educators, as students with disabilities, as parents of children with disabilities, and as human rights defenders, that we work together to change that system. The first point of that is knowing what inclusive education is, so you know what it is you are working toward. And it is a system that is there for all children, that is geographically local, that is physically local for the children, so that they're there with their peers of their society. So on that note, I am going to end, and I'm going to leave you with a quote from a great educator, and that's Dr. Seuss. And he said that the more that you read, the more things you will know. The more you learn, the more places you'll go. And on that note, I'll say thank you.
Thank you, Shivaun. I'm sure you'll agree with fascinating insight there on the right to education and knowing what inclusive education actually is. and the damaging impact of segregation education on children, and that education is a basic right which affects all other fundamental rights under the CRPD. I'd like to welcome now Anna Bruce. Anna is based at the Faculty of Law at Lund University and the Raoul Wallenberg Institute of Human Rights and Humanitarian Law. Anna has been teaching and researching disability human rights since 2001. She was involved in the negotiation of the convention, the CRPD, and she was also part of the post-gain schemes in Sweden, which many of you will be familiar with. Her presentation today talks about how the CRPD can be used to secure rights of children with post-traumatic stress disorder in refugee status determination. So I'd like to welcome Anna.
So, hello everyone. I'm delighted to be here today. The problem that I want to address is how the refugee status determination process disadvantages children with psychosocial disabilities, because this effectively diminishes their chance to get asylum and other forms of international protection. And the point of my presentation is to show that the CRPD does make far-reaching and specific demands on how refugee-receiving states are to remedy this disadvantage. So in order not to stay too general, I've narrowed down my focus to children with post-traumatic stress syndrome, and the problem description I'm using is relating to refugee-receiving states in Northern Europe, notably Sweden, which is where I come from and where I've done my research. So the outline of my presentation, I will start, because we're in a disability rather than in a migration context, I will start with an overview of the refugee status determination process. And I'm going to be calling it the RSD process, shorthand. Then I'll introduce the most central provisions in the CRPD that can be used to make demands on this process, particularly Article 13, but also 3 and 7. After this, I will illustrate the challenges facing children asylum seekers with PTSD. First of all, there's a legal threshold of qualifying as a child with disabilities and therefore being included under Article 1 of the CRPD. And after this, I've chosen two particular aspects. The first one is to be identified as a child with disabilities as a gate to getting the kind of accommodations that Article 13 demands. And the second aspect I want to talk about is the interaction between the child and the decision maker from the state deciding whether this child has the right to asylum or not. After this, I will briefly make the case, if I have the time, for universal design. Obviously, there's a reform of the RSD process is needed, but the way that reform is made can make it relevant to all asylum seekers or only asylum seekers with disabilities. So it's an intersectionality discussion that can be had there in the end, if time allows. And unfortunately, the intersection between disability, migration, and childhood is only starting to be explored. So I wish I could provide solutions, but what I can do is to provide an overview of how the CRPD can be used and what specific situations and problems that it should address. So the refugee status determination process, what is it? It starts by an application for asylum by the child or other forms of international protection, and it ends with the acceptance of that claim or the rejection and deportation. And the question for the process is, does an individual, in this case the child, have a legal right under national, international, regional law not to be sent away from the state in question? And there are different sources in international law for this right not to be sent away, but the central one is the definition of the refugee in the 1951 Refugee Convention. And the core question this definition asks is whether the person has a well-founded fear of persecution for reasons of race, religion, nationality, membership of a particular social group or political opinion, if returned to his or her country of origin or to his or her country of habitual residence. So the process answering this question involves retrieving relevant facts and circumstances about the individual and the place where he or she comes from, if it's the country of origin or the country of habitual residence. It also involves judging the credibility of the account of the individual, and this will become very important, as you will see in a minute. And so the process as such takes the form of oral and or written interaction between the state and the child or his or her representatives. And it's differently structured in different countries, but this interaction, oral and written interaction, is central to any RSD process. And finally, the RSD process is poorly regulated in international law, both in refugee law and in international human rights law, which is also why the CRPD, as the latest negotiated UN human rights instrument, has a lot of potential here. You can say that the rights of non-citizens are still largely viewed as a legitimate case apart, much like the procedural rights of persons with psychosocial disabilities. And this has led to that an acceptance of lesser procedural rights in the RSD process than in other administrative and legal processes that cater for the needs of citizens rather than the needs of non-citizens. So what does the CRPD have to say about the RSD process? It should be mentioned from the outset that in the negotiations of CRPD, migration remained a fringe issue. States were exceedingly unwilling to bring it up, and civil society did not engage much with it either, which means that you find little expressions of it in the CRPD. On the other hand, the inclusive mantra of the CRPD, all persons with disabilities, speaks for that it can be easily be interpreted as applying to non-citizens with disabilities as well. Also, there is no explicit exceptions in the CRPD. It nowhere says that these rights belong only to citizens. So it's definitely an argument that can and that is being made. Right now, so we're talking about the process, and then Article 13 becomes central on access to justice. And from this article, we know that all stages of the RSD procedure is covered. So the demands that are made by Article 13 are applicable from the first claim made, from the first time the person says, I'm applying for asylum, till the deportation stage if the claim is not accepted. So the guarantees in Article 13 are applicable to the whole process. From the preparatory works of the CRPD, we also know that it doesn't matter if a state refers to this process as an administrative one. It's still covered by Article 13, even though Article 13 says all legal proceedings. It was clear from the negotiations that it was also supposed to cover administrative procedures. So there's no way out there. We also know from Article 13 that two kinds of measures are always required: procedural and age-appropriate accommodations to the process, and appropriate training for all personnel. And in relation to the RSD process, and that means legal counsel, support persons, decision makers, persons who are to determine if the child has PTSD or not. So the whole range of people who come in contact with the child. Finally, in accordance with the trademark of the CRPD, the focus is on results. States must ensure effective access to justice, and they also must ensure an effective and participatory role for the child in this process. Now, the two other provisions that I wanted to mention was Article 7 and Article 3, but this has already been brilliantly done, so I don't need to say much. I just want to add that Article 7 on children with disabilities, it brings up both the best interest of the child principle and the respect for the evolving capacities of the child. And like it was said earlier, the best interest child is all dependent on how you interpret it. But in addition, I think from an interpretation point of view, you can make the case that when one principle was to be chosen to put in Article 3 to guide the entire interpretation of the CRPD, it was the principle about evolving capacities of the child and not the best interest principle. So I think this is also gives ground to argue for self-determination of children, not only in relation to the RSD process. So moving then to the kind of questions that the CRPD can be used to address. First of all, the threshold legal question is whether children with PTSD, post-traumatic stress disorder, are covered by the CRPD. And the short answer is yes. Article 1 of the CRPD reads, persons with disabilities include those who have long-term physical, mental, intellectual, or sensory impairment, which, in interaction with various barriers, may hinder their full and effective participation in society on an equal basis with others. So it sets up requirements both on an individual and on a social level. And in order to address the individual level, I refer to a diagnostic tool called DSM-5, Diagnostics and Statistical Manual of Mental Disorders. There's a lot to be said about this tool, but I won't say that here. I would rather just say that here it's about qualifying for protection, and the way that is built up is that it has an individual level. So that's where we end up doing that. From this we can see that PTSD is a mental impairment indeed of a certain level and duration, which in principle qualifies for the coverage of the CRPD. The characteristics or potential impairments of PTSD are divided into 4 categories. The first one is re-experiencing, and it involves spontaneous memories of a traumatic event, reoccurrent dreams related to it, flashbacks, or other intense or prolonged periods of psychological distress. Avoidance is the other category of impairments. It means avoiding, like taking action to avoid stressing memories, thoughts, feelings, or external reminders of the traumatic event. The 4th category is negative cognitions and mood. And it includes, for example, estrangement from others, markedly diminished interest in activities, and importantly here, an inability to remember key aspects of the traumatic event. The 4th category is arousal, and it includes aggressive, reckless, or self-destructive behavior, sleep disturbances, hypervigilance, or related. So all we need to take away from this now is that it qualifies principally as an impairment according to the CRPD. There's a tempo requirement. The symptoms must last for at least 1 month in the DSM-5. And this might lead to questioning whether it can be squared with the long-term requirement in Article 1 of the CRPD, requiring that in order for something to be covered by the CRPD, it has to be long-term. However, the reality, as well as the prognosis, often holds a much longer time frame for PTSD, particularly for children, and particularly if the child is subjected to the RSD process while recovering, or while supposedly recovering from PTSD. There's a lot more can be said about that, but the RSD process is really a prolonged life and death situation to be managed by the child, even under the best of circumstances, which are rarely present. So I don't think the long-term requirement would really hold any ground. So here we can say, for example, to note that if a child is separated from the family, the child is likely to worry about the family back home and might carry the heavy hopes of that family for family reunification if that child gets asylum granted. And even for children with PTSD who have a family present, the pressure on parents is formidable and may well affect the support that can be given to the child. Moving then to the social requirement of the CRPD, they're easy to meet. PTSD affects the ability to disclose information and communicate, and the appearance as credible and cooperative. So these abilities and appearances are decisive to the granting of asylum, and so PTSD, in tandem with an unaccompanying RSD process, is likely to result in diminishing opportunity for asylum. Like most aspects of the intersection between asylum and disability, this needs more study, but there is some evidence of this. There's an Australian study, for example, from 2010 that shows a correlation between the display of these symptoms and negative outcome of refugee status applications. So, in other words, an unaccommodating RSD process leads to children with disabilities unfairly being denied asylum. So now I want to look at 2 aspects of the process where this becomes a problem, this intersection between post-traumatic stress syndrome and the RSD process. First of all, Today, to be identified as a child covered by the CRPD or as a child with disabilities is the entry point to any kind of accommodations. It's a necessity to get that. So it means that, according to Article 13, states need to provide a procedure which establishes the status of the child as one with post-traumatic stress syndrome or one with disabilities. And the same goes for age, to establish age in order to provide age-appropriate accommodations. So, first of all, these procedures has to be in place. Secondly, CRPD has requirements on how these procedures are to work. The autonomy and the self-determination of the child, the right to be heard, that's not given away to parental, guardian, or medical authority, according to Article 3 and 7. And also, the dignity and physical and mental integrity of the child, protected in Article 3, but also in Article 17. And these requirements are central because the need for asylum is often such that both adults and children are willing to endure a lot in order to have a chance to the good, which is asylum, to that which is at stake. And in such a situation, a person is not likely to protest when being measured or probed at or willed to buy into a victimizing, pacifying stereotype in order to get protection. There's too much at stake, which is why it's crucial how these procedures are organized. And finally, the competence of the assessors regarding psychosocial impairments, that these assessors that are supposed to identify the child as one with disabilities has psychosocial competence and not only somatic competence, which is common. So, what are the challenges here? First of all, are examinations offered at all? This is often not the case. If these examinations are voluntary, how many attend them? And those who assess the child may also not know that a diagnosis should affect the procedure, so that you should get procedural accommodations based on this. And the child or the child's parents may also think that a diagnosis will not lead to procedural accommodations, but rather will be negative in the asylum procedure. So there might be an unwillingness of families to admit the condition of the child, particularly if this is the case. Age assessments in particular are physically intrusive, but as I mentioned before, they're hard to deny. And these challenges are different for children to seek asylum as part of a family and children who are unaccompanied. An accompanied child may, if a guardian is supplied, have more access to these procedures than a child who comes with a family. And also may more readily be heard since there are no parents available to speak for the child. At the same time, a family may more easily detect change in a child they know and seek help. So the point is that no status is unproblematic, but they have different challenges. Secondly, in the meeting point between the child and the person who will decide whether the child has a right to asylum or not, what does the CRPD require of this dialogue? First of all, the decision maker has to have the child and disability competence to provide information in a way that reaches the child and to be able to communicate with the child. And this ability crucially involves the ability to read the account of the child with PTSD in an adequate manner. So in what way may the PTSD influence the consistency of the account and the ability of the child to provide details to support that account? And in what way may the behavior of the child as non-cooperative or the account as non-credible be put down to the PTSD and not the child not qualifying for asylum? Article 13, again, also puts requirement on the organisation of the interview, and Article 13, 3 and 7, a real commitment to the rights of the child to actively participate and to get the support that's needed to do that. Finally, and importantly, particularly in relation to children, that the decision maker needs to, and if the child comes as part of a family, the decision maker needs to inquire into the own asylum grounds that the child might have, not only as an accessory to the parents that the child is coming with. And this is particularly important as the disability may be linked to grounds for asylum. So The challenges here are many, as current experiences indicate. The decision maker may misinterpret accounts that change or lack of details and judge the account as non-credible. And reluctance to share information and the general demeanour of the child with PTSD may be interpreted as not fulfilling the obligation to cooperate. So this is part of a wider inability of the decision maker to communicate with the child and to impart information in the way that the child can understand. The venue may not be suitably arranged, needed support persons may not be called, an interpreter may not be briefed on the conditions on the child. The decision maker may not even know that a diagnosis is supposed to give procedural accommodations. And also the decision maker has the main responsibility to make sure that all the other actors in the process actually have the capacity that they need. So the legal counsel, support persons, interpreters, and so on. So the point is again here, and I don't have time to go through that, but that both statuses as being an unaccompanied child and being a child coming as part of a family has its own challenges here, particularly in relations to the procedure, which means that while it's always very important to keep an extra focus on unaccompanied minors, this does not mean that focus should go away from the risks of a child coming with a family, because there all the usual dangers of being a child and being a child with disabilities as part of a family come up more. There's a distance between the system of the receiving state and the child coming that needs to be dealt with. Finally, and very quickly, what kind of reform? The reform the RSD process that the CRPD requires of the RSD process requires change, but change can take many forms. And I want to argue that states should not focus only on providing a parallel procedural track for the persons covered by the CRPD, but to endeavour to have a process which is compatible with a larger range of functioning among human beings. And I think there's legal arguments that can be made on the grounds of the CRPD, which I will not develop here. But they relate to a logical progression in the CRPD from general to specific measures. You start with the general, then you get to the specific. They also relate to obligations to counteract prejudice and stigma, and they also relate to provisions speaking against medical evaluation as a gatekeeper of non-medical life opportunities. But the strongest argument is in humanitarian terms that you will not be able to identify all the children who have the right to the protection of the CRPD if you have this system. And another motivation, of course, is that universal design extends the legal relevance of the CRPD to asylum seekers in general. And precisely therefore, these arguments will have little political traction. Anything which is likely to attract rather than deter asylum seekers is currently unthinkable in the race to the bottom to deter asylum seekers from Europe. This, of course, makes it even more important that the RSD procedure can violate human rights instruments that cater primarily to other grounds, but they're also applicable to non-citizens and asylum seekers. So in order for asylum-seeking children with PTSD to enjoy their rights, all these instruments must be implemented in concert. So the Convention on the Rights of the Child, the instruments that are part of refugee law, and the CRPD. And at the moment, the CRPD is not there. And more importantly, these instruments must be allowed to make a difference, even when they fly in the face of the interest of migration control. And we've seen this problem many times in relation to interpreting the best interests of the child in relation to migration. So a universally designed RSD process extends the relevance of the CRPD to asylum seekers generally. And so this is intersectionality at its best, I think, when the legal and ideological ground gained in relation to one form of oppression can be expanded to another. Thank you.
Thank you, Anna, and an insightful presentation into how the CRPD can reform and be used in the RSD process. So I'm sure you'll agree, some thought-provoking presentations there on the rights of children with psychosocial disabilities from our panellists. So we have about 5 minutes, so we should have time for about 3 questions if people have any questions they want to pose to the panel.